Today, the Ethics and Anti-Corruption Commission welcomes the judgment of the Anti-Corruption Court sitting in Milimani, where the court has found the former governor of Samburu guilty of various corruption offenses. These include conflict of interest, fraudulent acquisition of public property, all of them relating to a case where the convict, that is the former governor, traded with the county government of Samburu during his 2 terms as governor. The ruling delivered by the court today has served justice to the people of Samburu. It is a ruling that EACC finds significant in a number of ways. For instance, this is the first corruption case of a criminal nature that has come to its logical conclusion, even despite the attempt that the DPP made earlier during the proceedings to withdraw the case. It is the first corruption case of a criminal nature where the court has found the accused persons guilty. In this case, we have the former governor, Lonolkulal, the then county secretary, and the other senior county officials. Today, the court has rendered its ruling, and the sentencing will be done tomorrow. The other way in which this case is significant is that it sends a message to all public officers, both at the national and the county governments, that there are consequences when one betrays public trust. When we talk about conflict of interest, such as the one that the former governor has been found guilty of, it is important to remember that conflict of interest is the bedrock of most of the mega corruption scandals that the country is grappling with. Today, we have over 40 sitting and former governors that are facing this kind of cases involving conflict of interest, which cases are at various stages in the criminal justice system. We have some that are under investigations by the EACC. Those involving 2 governors have just been completed, and the files are on their way to the DPP recommending prosecution. We have other files still involving governors, part of the 40, that are pending review and a decision by the DPP on whether or not to prosecute. And then we have other cases, part of the 40, that are pending before the Anti-Corruption Court. The matters that were in court were 10 until sometimes 2 weeks ago, when one of the cases involving a sitting governor was withdrawn by the DPP. So we have 9. When you remove this one that has been concluded, we now have 8 governors, that is former and current, with the cases pending before the court. The court has also rendered itself on the issue of withdrawal of cases. EACC remains opposed to the withdrawal of corruption cases during the trial. And therefore, it is good that the earlier attempts to withdraw this particular one did not bear fruit. EACC sends a warning to public officials that are engaging in a conflict of interest at the county government and the national government to know that their day in court will come. Some may ask why this case has taken around 5 years. It is because of the institutional capacity that is available within the criminal justice sector. It means that if we can strengthen the critical agencies that are involved in the fight against corruption, that is the EACC, DPP, and the judiciary, so that we have more investigators, more prosecutors, and more magistrates. That means we can be able to handle more cases at the same time. So those with cases who are yet to be subjected to the court process should not think that they are off the hook. When their time comes, action will be taken.